of Spire Healthcare Ltd and World and Son Alliance Insurance.
Yes, Mr. Eckland.
It's Mr. Elkington.
Well, I wondered about that. How embarrassing. However, I will make it up to you by saying that I think the court will be more assisted by hearing from Mr. Shapiro first. You may want a minute to get your thoughts in order, or you'll bounce straight into it, Mr. Shapiro.
My lord, I'm with a bit of rearrangement. May I?
Yes, no, that's perfectly understood.
My lord, in that case, may I address the key two issues?
Yes.
In the matter. First, what is the court seeking to identify by the original cause or source? And the short answer to that is we say the question is to identify the reason or explanation why particular claims arose. And second, against that background, whether all the claims arose out of one original cause or source or two. And as your lordships will know from our skeleton, we say there are two quite distinct courses of conduct. Group one, where the patient has a tumour and requires a mastectomy. And what is performed by Mr. Patterson in about 30% of the instances across the NHS and the private sector where a mastectomy is required is a subtotal mastectomy, which in and of itself is a negligent performance of the mastectomy, because no body of competent medical opinion would agree with Mr. Patterson it was appropriate to leave any breast tissue, because that then leaves a risk of a recurrence of the tumour. He performed those subtotal mastectomies in about 30% of the cases. In some of the cases, he actually said to the patients, I'm going to perform what he termed a cleavage-sparing mastectomy, but nobody else would use that term. And so he got their consent to perform effectively a subtotal mastectomy, but without telling them two things. First, that he had committed to stopping the particular practice, and second, that it would increase the risk of a recurrence of cancer. In other instances, he appears to have performed a subtotal mastectomy while meaning to perform a proper mastectomy. In other words, it was simply a negligent performance of the mastectomy operation. In the group 2 cases, as we've termed them, there is, in our submission, a very, very different, and as the Court of Appeal Criminal Division noted, almost a course of conduct that's inexplicable for a doctor to have engaged in, where the starting point is a dishonest diagnosis of cancer, and that the patient either has a tumour or a risk of a tumour. And from that dishonest diagnosis, Mr. Patterson says, well, you've got to have an operation. Typically, it was a wide local excision, which is where just a part of the breast is removed. In practice, what he tended to perform was more in the nature of a biopsy, where an even smaller part of the breast is removed than for a wide local excision. Of course, that makes no difference to the patient because there is no tumour. The operation is entirely unnecessary. And that effectively is assaulting the patient for financial gain. He then claims under their either their insurance or from the patient, and using cancer codes and for the wide local excision, which has a higher rate. And that course of conduct is continued in the private sector almost exclusively. There are one or two examples of the conduct in the NHS. But before the judge, there were 3 reports. One, the Veritar report, which was commissioned by Spire into the practices that were going on in Spire hospitals and that dealt with both types of conduct because he had performed both types of conduct in Spire hospitals. There was then the Kennedy report, which was commissioned by the NHS Trust, and that essentially focused only on the Group 1 claims because the Group 1 conduct was going on in the NHS hospitals, but not in, but no Group 2 conduct really was going on, and it certainly wasn't known about. And then there's the third of the reports, the inquiry by the Bishop of Norwich, and that dealt with both what was going on in the private sector and what was going on in the NHS, and that covered both forms of conduct. In our submission, the two forms of conduct are strikingly different. And if I put it in terms of if one was having a conversation with somebody and explaining, well, what went on, the key thing from an aggregation point of view is that there should be an explanation available to that person of what went on. And if one simply says, Mr. Patterson, and stops, or Mr. Patterson and his conduct, that doesn't properly explain what was going on. Because there's, in my submission, a fundamental difference between performing the right operation that is required incompetently and performing what can only be categorised and was categorised by the criminal courts as an assault.
Well, it depends what question you're asking, the purpose for which you're asking it. If you're asking something like, why is the hospital having to pay, it might make perfect sense, might it not, to say, because Mr. Patterson conducted his clinical practice in breach of his duty to his patients.
Certainly for the NHS Trust that was also sued, the Spire's position is slightly different to the private hospital. But I agree, I respectively assume that the thrust of my Lord's question is, well, why was Spire liable?
Yes.
And Spire
not necessarily as a matter of narrow legal analysis, because there is more than one route to that, whether, as you say, an adventurous or a development of vicarious liability, if it would be a development, or one of or their own negligence. The basic cause, an ordinary person might say, is they were using a doctor who mistreated his patients.
Well, my Lord, that is necessarily true. Mr. Patterson is involved necessarily in all the cases. So if one looks at matters in a global way, then what my Lord has said is certainly correct. The question, the submission that I would make is that doesn't answer the why. And in particular, it doesn't explain why he's engaged in two different courses of conduct in the private sector, and only one of those in the NHS. It doesn't help one understand why one might engage in the second course of conduct, having started...
Why is that relevant to a point of construction of an insurance policy? Why does the reason why he does it have anything to do with it?
Well, my lady, it doesn't affect the entitlement to indemnity.
No.
But in my submission, so that I entirely accept. In my
the judge spent an awful lot of time, forgive me for talking over you, but the judge spent a lot of time sort of delving into the motivation, which seems to me, with the greatest respect to the judge, to have nothing to do with the issue with which we are concerned. You say the original causal source, you ask yourself the reason why the claims arose. Can I ask you which claims we're talking about? The claims by the patients against the hospital, or the claims by the the claim by the hospital on the insurance policy, or both?
Well, both would be relevant. One's got to assess it from the point of view of the hospital, and so the claim in both directions would be relevant.
Because if you ask yourself, why is the hospital responsible? It's responsible, as my lord says, because they have a responsibility, in wide terms, legal responsibility, whatever label you attach to it, for the misconduct of a rogue surgeon. See, if you're right, let me put this to you. Suppose that you've got one surgeon who's an orthopod. Yeah? On day one, he misdiagnoses patient A, who presents with a fracture, which is a compound fracture which is not yet completed. And because he misses this, the fracture then completes and the poor patient ends up in a worse state. That's day one.
Yes.
Day two, he botches an operation on another patient when he's trying to put something right. And day three, he tells the nursing staff how to look after another patient who's in recovery and gives them misleading information, which leads to the patient having a much worse recovery, a slower recovery than they otherwise would have done. Now, in all three examples I've given you, he's done something which is substandard for a doctor or for an orthopaedic surgeon, which is negligent in the Bolam sense. But would you say that there are three operative causes and therefore the 10 million limit would apply to each of them?
Yes, unless the yes, if the mistakes are separate, unless what one's complaining about is the because this isn't a policy, and it could have been, where there was aggregation by surgeon.
Yeah, but if you're right, it then means that you can distinguish every single case where a patient complains, because every single case will turn on its own facts, and the negligent conduct, even as between patients within group one, would be different. You've told us yourself that in some cases the STMs were botched full mastectomies which weren't necessarily deliberate, and in other cases they were deliberate. So why isn't there a subtotal there?
My lady, one of the difficulties there is because Mr. Patterson has never, beyond preparing a statement and then giving a no-comment interview, has never given evidence. Nobody has been able to get to the bottom of the split between the two groups.
Doesn't that show the unsatisfactory nature of making the construction of this term depend on subtle questions of motivation? What if his motivation was partly dishonest and partly negligent, or was a mixture? He makes a mistake and then dishonestly covers it up. And it may be quite difficult to know whether the ultimate injury is the result of one or the other or somewhere in between. It's you immediately have to start making very messy distinctions. They may seem reasonably straightforward in this case. I'm not quite sure they're as straightforward as they've been presented, but even whether or not they're straightforward in this case, they might not be in another.
My lord, could I try answering that in a slightly roundabout way and ask my lord to look at one of the authorities?
Yes, certainly. But just before you do that, in case we lose it, I probably should have picked this up in the papers somewhere. If I did, if it's there and I didn't, I apologise. You say this is not a policy where there's aggregation by surgeon, as there could be. Was there evidence that it is a known form of policy for hospital groups or people employing doctors to have separate limits by surgeon, or were you simply meaning theoretically there could have had a limit for each doctor whose services you use.
The latter, my lord.
Right, I see.
But it was accepted as part of the common ground that there isn't express aggregation by surgeon. We did have an example of aggregation by individual within the cases before the court below.
Yes. Okay.
So one can have it certainly in other contexts.
Yeah. Fair enough. Yes, I think I know the case you mean. Anyway, let's go to the authority you want to take us to. Which one was it?
It's in bundle 1 behind tab 9, the countrywide and martial. And it's Mr. Justice Morrison's point, starting on page 118 of the bundle, paragraph 50.
So, 118 of the bundle, yes.
118 of the bundle. He's dealing with a number of pension mis-selling cases and is trying to determine whether they're all arising out of one original cause or a number of original causes.
Can we just see the terms of the clause?
Yes.
I don't suppose anything turns on them, but just for
the clause
order's
is
sake.
on 113, my lord. And if
Yeah, I know. I see it. It's the top of the second column. It's 5.
Any claim or any loss shall mean one occurrence or all occurrences of a series consequent upon or attributable.
Yes. So in fact, just like ours. Yeah. Thank you.
And the distinction Mr. Justice Morrison draws, and in our submission correctly, is between events and causes. And over the page on 119, he's explaining that whilst an event, occurrence, or claim is something that happens in a particular time, in a particular place, and in a particular way, a cause is not just something...
Sorry, can you speak up a little?
Sorry, I'm so sorry.
No, don't worry at all. Or if you'd rather us just read it to ourselves, but if you're...
May I ask you to...
Yes, just to the end of that paragraph 15.
Yes, please.
Thank you. Yes, thank you.
And we rely principally on the word cause describes why something has happened. And that's the starting point for asking to look at why something has happened.
Well, I mean, that's if I say so, a truism. But as we all know from hundreds of areas of the law, you can characterize the reason why something happened in all sorts of different ways, depending on the purpose for which you're asking the question. So does this, if that's really the only thing you get out of it, it doesn't get you very far, does it?
Well, if one reads on in that passage, you're looking to see whether there is a unifying factor in the history of the claims. In my view, the lack of proper training of the selling agents and selling employees was behind the whole problem. So he's found a unifying factor, notwithstanding that you've got different agents who are individually responsible. Why can't the unifying factor in this particular case being that Mr. Patterson was a rogue surgeon?
Well, my lady, it's ultimately, as Lord Justice Ricks observed, a question of judgment for the court based on the facts and the clause. So I wouldn't have the temerity to suggest to your ladyship that it was impossible to come to that view at all. The judge, having had the benefit of a much fuller appreciation of the evidence, came to a different view.
But he was talking about motivation. And with the greatest respect to him, I can't see what motivation has got to do with it. I can see the entirely understand the force of the argument that you've got different types of bad behaviour. In the one case, operating on people who don't need operations at all, and in the other, botching the operations on the people who do. Understand that argument altogether. That wasn't quite how the judge approached it. He started talking about motive.
Well, in my submission, it's if I divert from the case I was going to take you two next and just ask the other side of aggregation is event. And there, the normal test for whether something's an event is the 4 unities that comes from Michael Kerr, QC as he then was, the Dawson Field Award. And the 4th of those is the intent of the actors. So when there's human agency involved, one does look at the intent of the actors. We don't have the event cases in the bundle, but I could make that good from Scott and Copenhagen Reinsurance, which is behind tab 10 of your ladyship's
I mean, event policies are something with which I'm fairly familiar, Mr. Shapiro. But take us to Scott if you want to. Lord Justice Ricks.
Lord Justice Ricks, at paragraph 23 on page 128 of the bundle. This is just the convenient summary of the 4 unities which were applied later. And at the bottom of paragraph 23, he's discussing Mr. Michael Kerr QC, later Lord Justice Kerr, in the Dawson's Field arbitration, itself quoted at length in KIC and KIC. The last 2 cases illustrate the usefulness of testing the question of one event, or in KIC, it was any one occurrence, by referring to factors, so-called unities, such as cause, locality, time, and the intentions of any human agents. So on the event side, it's expressly part of the court's consideration of whether something's an event, that it has intent. One looks at the intention of any human actors involved. And in practice, in my submission, where human actors are involved, that's what the court has done on the original cause side. So if I could ask your lordships, please, to turn up.
Just before you leave that, he says unities such as cause, locality, time, and the intentions of any human agents. That doesn't mean that the intention is always relevant. That will depend on the nature of the liability, won't it?
Yes, and whether there's a human actor involved. So if one's talking about whether, if the event's a hurricane,
earthquake.
Obviously,
Yes.
an earthquake, yes.
Yeah, if initiated by human action was what Lord Justice Carr said in Dawson's Field, the quotation just before paragraph 24. If initiated by human action, the circumstances and purposes of the persons responsible.
Yes, my lady. And here in my submission, this is something which is initiated by Mr. Patterson.
Where does that get you?
Well, it gets me. It takes me at least as far as saying that on the event side of things, there's been express suggestion that where a human actor is part of the event, one should be looking at intentions. And in practice, as I hope to show, my lord,
Well, I need a bit of help on that. Why should you... For determination of what issue? Well, at the moment, I'm sure this should be more familiar to me than it is, but in determining whether something is an event for the purpose of an insurance policy, where the thing in question is done by a human, a person, why is it axiomatically necessary to look at that person's thought processes? May or may not, mightn't it? Just give me an example.
Of an event. So for
give an example of where, for the purpose of characterizing something as an event, it is necessary to decide what the purposes of the human actor are?
Well, in the Dawson's Field Award, one has the 3 planes which are blown up at Dawson's Field, and they're blown up in the space of somewhere between 6 and 10 minutes. I'm afraid I can't remember the exact time. And part of the decision for it being a single event is that there's a decision taken by the terrorists to blow up the 3 planes.
Yes, I see. Time. Okay, that's a very good example. Thank you. That won't always be the case.
No.
No. No. Okay, I know. That's been very helpful.
A discussion of the meaning of event doesn't seem to me to be very helpful. I mean, as I can't remember whether it's your skeleton argument or the appellant's points out, what is the cause of something is a much more difficult question, especially if you ask it in the abstract. Can I put this to you? As it happens, in this case, it doesn't matter whether there were 2 causes or 20 or 200, because we have a nice neat problem, as there was a moot at a university where you've got $1 of liability, 10 million, $1 of liability, another 10 million, and beyond that it doesn't matter because there's a overall total of 20, as I understand it. But why do you say, if you're right that different types of wrongdoing by Mr. Patterson are to be treated as differently, why is it 2 rather than 20 or 200?
Well, my lord, because of the courses of conduct that he was engaged in, it could have been 3 or 4 or as my lord postulates, 200.
Is it fair to summarise your 2 groups as being negligence and dishonesty?
Yes, and that's how it was reflected in the pleadings and then in the agreed list of issues. Effectively, Group 1 is negligent medical treatment. Group 2 is a dishonest assault on a patient who requires no treatment.
But I think you accepted in answer to my question that actually you could have subgroups of negligence. In the example of the orthopaedic surgeon I gave you, there were 3 different types of negligence with the same person involved, and you say, well, they're all separate causes.
It always depends on the facts, my lady, and so for example, in our hypothetical examples, where one has, say, a general surgeon performing carpal tunnel releases and doing those consistently negligently so as to cut the nerve in the course of performing a carpal tunnel syndrome release, that, in our submission, would be the same type of error, the same cause, and those would all aggregate. But we would say, for example, if he incompetently was using the wrong type of hip replacement, or if he was using the wrong screws to fix a knee, that would be a different type of problem.
Don't you get into the risk of endless arbitrary fine distinctions? Oh, well, in this case, where he was doing the carpal tunnel syndrome, he cut that nerve because he allowed his scalpel to slip to the left. This one, he allowed his scalpel to slip to the right and he cut that nerve. Why isn't that an appropriate distinction, if your analysis is correct?
Well, my lord, the principal answer is there is a point at which one takes the analysis.
Yes.
And the difference between my lord and the questions my lord is asking me and my submissions is that I'm submitting that one takes the point of analysis to a level that provides an explanation of the conduct that results. One doesn't simply say it's enough to identify the particular surgeon. And while it may, I sense from the question that it feels odd to my Lady Andrews that you could have multiple originating causes from the three operations postulated. In my submission, if they're properly different errors, and that's the reason for it, then there would be different originating causes. If
it would
he's
make a commercial nonsense of an aggregation clause if you were right, I'm afraid, because you would end up with, as my lord says, endlessly fine distinctions about the nature of the negligence of the surgeon. It's a different matter if you've got two separate surgeons, one of whom is a regular botcher of carpal tunnel operations and the other one who amputates the wrong leg. But when you've got the same surgeon who's basically an incompetent surgeon and who negligently botches up operations on different patients or exposes his employer or the person where he's in the hospital where he's working to exposure to liability for his negligence, I can't at the moment see why you should start distinguishing between different types of negligence to say that the causes are different.
well, if the ultimate cause is that he is just simply thoroughly incompetent, I accept my lady's on that characterization. Yes.
Right. So it makes so the distinction really is you can have a single cause if it's an incompetent surgeon, but if he is both incompetent and dishonest, then the dishonesty somehow sort of goes into a separate cause.
Well, it's certainly true that if he's incompetent and dishonest, in my submission, the dishonesty, which is fundamental to the Group 2 cases, but not to the Group 1 cases, would take it into a separate category.
It wasn't fundamental to the liability, was it?
Well, the liability was limited to claimant negligence for two reasons. One, that was all that the claimants needed to prove, and indeed was admitted by Mr. Patterson. And then, as your lordships may have seen, or my lady may have seen from the second tab of the supplemental bundle, it was agreed, and Miss Justice Foskett made an order, that the assault allegations wouldn't be part of the lead claims, because at that stage the criminal trial was ongoing, and so the parties very sensibly removed all the assault allegations from the underlying civil proceedings.
So you're saying it would have made a difference. It would have more obviously made a difference, and the fact it wasn't pleaded this way shouldn't change it, if we characterise these claims as claims of assault.
Yes.
That's not actually the way the judge decided it, is it? He, as my lady said, seems to have focused essentially on the question of dishonesty, but is another way of putting your case that one category of cases are negligence cases and the other are assault cases.
Yes.
More accurately, I think, you'd have to say, because negligence, although it's a shorthand we all use, is breach of a duty of care, they're all cases of breach of a duty of care. It's just some of them are assault as well. Yes. And that's the distinction you're drawing.
Yes.
Yes.
Yes, the distinction is that the second group, it starts from a false diagnosis, has an assault, and for the sole purposes of financial gain. And we say that's fundamentally different conduct to the performance of a mastectomy that's required because there's a tumour in the breast and it requires to be removed. And the flip side is if one simply says breach of duty or negligence is all that is required for it to be an originating cause, then given that almost all policies are responding to tortious liability, one is almost invariably going to have aggregation in every case. So in my submission, one does need to look beyond the mere label negligence.
Wait a minute. Why does the fact that you would have aggregation in every case mean that you, but because all liability, all medical liability is tortious, why does that mean that that's an unacceptable result?
Because, my lord, the presence of the aggregation clause assumes that in some instances one will have multiple claims falling within the clause and subject to
Oh, certainly, but the most obvious case would be against different doctors.
Yeah.
Now, one way of looking at this, and the way I'm bound to say attracts me at the moment, is insofar as anyone really thought about this, which of course one knows that too often they don't. If you ask what's the purpose of having this, it means, well, so that, or what's the effect of this? It's that if you have claim, if you are unlucky enough to employ two different negligent doctors, you go to the full limit of cover for both. You don't have to agree with that, but the suggestion that the aggregation clause will be pointless, that seems to me, which I think you were making, if the appellant were right, surely falls at that hurdle, doesn't it? It certainly wouldn't be pointless. It would be, obviously, depending where you draw the line, be more or less beneficial. But
my lord, I agree if one distinguishes between doctors, and I would submit that the reason one's distinguishing between doctors is because the doctors are making different mistakes. If they're working in concert and performing the same mistake, then one might well aggregate.
Well, that's a complication, unless it's important to you. I mean, if you have different doctors and different days, maybe performing completely different procedures, then there's obviously no unifying factor.
Yes. Here one has a situation where the breast nurse who was employed, Bethan Lloyd-Owen, was complicit in what was going on with Mr. Patterson. And so that would be an example where one would have two people engaged in the same course of conduct. So I don't suggest, for example, that there's then two groups, one to do with Bethan Lloyd-Owen and one to do with Mr. Patterson. But it is relevant, and I say that from looking at why the two doctors should be treated separately, specifically, are they doing something differently, one also gets to thinking, well, why is one aggregating a number of claims arising out of the same doctor? And could I ask my lord to turn up in the first authorities bundle, Cox and Bankside Members Agency, please, behind tab 3.
This is Miss Justice Phillips.
This is Mr. Justice Phillips.
Just give me one moment while I just make a note. Yes, I'm so sorry, yes.
Could I ask my lord to turn through to page 37, please? This is where Mr. Justice Phillips is discussing originating cause, and the remainder of the decision was relevant to the order in which underwriters who were negligent could claim under their E&O cover, and whether or not it was based on liability being established, or whether you would hold things back and have an appropriate allocation so that various claimants would all be able to claim when they made the claim, as opposed to the insurance meeting the claims as and when ascertained. And that part of the decision gets overturned when it goes to the Court of Appeal. This part of the decision isn't. And at this stage, the question is, if the liability established in Deeney and Gouda Walker arises from more than one originating cause, how many originating causes? And it follows the Gouda Walker judgment. This is column 1 on page 454. At this stage, Mr. Sumption, who was one of the counsel in the case, was founding his assumptions on the decision of Mr. Justice Clark in Caudle and Sharp. That decision is then overturned by the Court of Appeal, who find that Mr. Outhwaite's blind spot about writing asbestos runoff cover is not an event. That's a judgment of Lord Justice Evans when Caudle and Sharp goes to the appeal. But at that stage, it had been held that the losses in question arose out of a liability to names incurred by Richard Outhwaite in concluding on their behalf 32 runoff contracts. And the arbitrators had held that those losses were the consequence of one event. Then over on column 2, Mr. Sumption argued that similarly, in the case of Gouda Walker, a single originating cause was responsible for all the losses, in respect of which the names recovered judgment. He was trying to say, well, look, it was one event in terms of the blind spot. The blind spot is similarly one originating cause. And he suggested at the little paragraphs numbered 1 to 4, the various possible originating causes, going from successive failures by a particular underwriter to pay due regard to proper principles of underwriting stemming from one originating cause, through to at 4, loss deriving from disregard of proper principles by different underwriters writing different books and employed by different assureds within the Gouda Walker organisation, stem from the same originating cause. And he suggested in each of the examples 1 to 4 above, the originating cause was a disregard of proper principles of underwriting or a promulgation of the wrong principles by effectively the management of Gouda Walker. In contrast, Mr. Voss, QC as he then was submitting that there were 4 separate originating causes, each giving rise to an independent third-party liability. And the first of those is the negligence of Derek Walker. So he's effectively underwriter number 1, and he was negligent in underwriting Syndicate 290 and part of 164 without rating the business properly, appreciating the risk to its names or informing the names of it. Then the second one is the negligence of Stan Andrews, so a second underwriter, in underwriting for 298 without monitoring aggregates, competently estimating its exposure or having a proper appreciation of the extent of lost business. The third and fourth are the negligence of the same underwriter. The negligence of Mr. Willard in underwriting for 299 in 88, without calculating probable maximum loss or placing adequate reinsurance. And then at 4, the negligence of Mr. Willard again in underwriting for 89 on a basis that was bound to result in a loss to his names. And the way Mr. Sumption's submissions were put, the simplest was that the one originating cause was the lack of any proper formulation and implementation of underwriting policy at board level, treating the two Gouda Walker agency companies as a single organisation or unit for this purpose. And then Mr. Justice Phillips quoted from his judgment in Gouda Walker, and then he goes on at the bottom of column 1 to pick up the alternative submission made by Mr. Sumption. He submitted that the negligence displayed by each of the Gouda Walker underwriters was essentially identical, a failure to appreciate the gearing effect of the spiral and the nature of the problems to which any steps that they took to protect their names had to be directed. And the submission made, which worked on the basis of Caudle and Sharp, as it then was before it went to the Court of Appeal, was just as Mr. Outhwaite's lack of appreciation of the consequences of asbestosis was a single event which was the cause of the losses that flowed from the 32 disastrous run-off contracts. So the lack of appreciation of the effect of the spiral was a single originating cause responsible for all the Gouda Walker losses. And this is the passage which we relied on below before His Honour Judge Pelling, and which hadn't been challenged in the appeal by the appellant. In my judgment, this reasoning is fallacious. A culpable misappreciation in an individual, which leads him to commit a number of negligent acts, can arguably be said to be the single event or originating cause responsible for all the negligent acts and their consequences. The same is not true when a number of individuals each act under an individual misappreciation, even if the nature of that misappreciation is the same.
I would have thought that supports your opponent rather than you. Mm.
And then, well, I say necessarily logically, my lady, if one's got a separate misappreciation which isn't connected, so in other words, even if it happens to be the same, they arrive at it independently, the reason one's not treating that as aggregating together is because the cause of their misappreciation is different. That's why I say
if they look into a person's mind to find out what causes them to do something. Strikes me as being an exceptionally difficult way of looking at it. Whereas what Will Phillips appears to be saying here is if it's an individual who's responsible for a number of negligent acts, that's one single cause, but you can't say that because everybody else is labouring under the same misapprehension as him that they are also contributing to the same cause.
Well, my lady, what he goes on to say is that each of the Gouda Walker underwriters formed his own policy insofar as he had one. And then the approach to underwriting of each underwriter was a separate originating cause. And then in the next paragraph, he says, I do not, however, accept Mr. Voss's submission that Mr. Willard's underwriting for the 89 year constituted an additional originating cause to his underwriting for the 88 year. This submission was based on the assertion that Mr. Willard's acts of negligence in 89 were separate and distinct from his acts of negligence in 88. Oh. I do not agree. And then he quotes from his judgment in Gouda Walker, Mr. Willard's policy in relation to the exposure flowing from his syndicate's excess of loss business did not alter between 88 and 89. And in my submission, it necessarily follows that if it had altered, there would be a different originating cause.
I don't see how any of this helps you at all. I mean, suppose there had been another, heaven forbid, equally rogue surgeon doing the same negligent or dishonest acts on another floor of the hospital, operating separately, then that would be a different original cause or source. Of course it would. But why do any of these examples help you? They all seem to me, speaking for myself, to help the other side.
The nearest thing, I respectfully agree with my lord and my lady about the first part of Mr. Justice Phillips's reasoning that you've relied on. I see your point based on the paragraph in the middle of the second column, where I understand your submission to be that it necessarily follows that if Mr. Willard had made a different kind of mistake in relation to 89 than in relation to 88, not quite clear what it would be, then Mr. Justice Phillips would have held that they couldn't be aggregated. That's your submission on that paragraph. It's building rather a lot on a little, isn't it?
It's building on the response to the submission being made, which isn't to say, look, it's Mr. Willard in both instances, therefore necessarily that's one originating cause. That wasn't the answer.
Well, I think you're trying, with respect, to make a positive out of a negative. What Mr. Justice Phillips was saying is the basis, the factual basis for Mr. Voss's submission isn't made out.
Yeah.
And therefore, because his whole submission necessarily is premised on two different types of negligence, it falls at the first hurdle. He's not saying, well, if that factual premise had been made out, I might have thought it was a good point. He doesn't need to go that far. What he's basically saying is that Mr. Voss's submission falls afoul of the fact that, in fact, Mr. Willard applied exactly the same policy 2 years consecutively, in terms of looking at the spiral. So I don't think you can even go as far as you're submitting with the greatest respect. I think you're reading too much into this passage. There's nothing in this that I can see that indicates that Mr. Justice Phillips would have accepted that submission if the factual premise for it had been made out. Sorry to give you a hard time about it, but...
My lady, the other area where the other example from the authorities which we relied on is in the second authority bundle behind tab 20. The Cultural Foundation Beasley Furlong decision of Andrew Henshaw QC, as he then was. And at 392 of the pagination within the bundle, we rely upon paragraph 204. May I ask your ladyship just to have a look at that, because that does expressly say.
Tab?
It's 20 in bundle 2.
Yes. Sorry, please give me the reference again.
392 is the page reference.
Yes.
I think it would certainly help me to have just be given a short introduction to what the nature of the issue, what the circumstances were in which the issue arose. I see it's an architect's liability claim. Is that right?
It's an architect's liability claim, and it was on a project where there were a number of different claims being made. One was in relation to the structural engineering of the building which had been designed, The other was in the nature of a delay claim relating to the detailed designs which had been produced, not facilitating the efficient construction of the project. And there was an issue about whether or not one of the many issues in the case, was whether the structural engineering issues, which got referred to in the case as the Sector A columns issues, and then the delay issues, which were being referred to as the Notification 923 issues, arose from the same original cause.
My immediate reaction on looking at this is, you may well be right, but the circumstances are so different that it doesn't really help us. Aggregation clauses arise in all sorts of different contexts and have to be applied to all sorts of different circumstances. Suppose this is right, what principle arises out of it which helps us to solve or helps us to resolve the issue in this case in your favour, or indeed to resolve it at all?
Well, in my submission, the principle is that one should be looking for an originating cause at a less generalised level than with respect your lordships are suggesting to me that we should be looking at it. And
yes, but this is a different context. There's no question here of multiple individual actors. I mean, no doubt this whoever the RMJM, no doubt employed lots of people, but there's no question of individual liabilities. And the question was being asked in a quite different context. Why would you have an aggregation clause in a case of a insurance? I don't know whether the insurance was specific to this particular project or whether it was, as it were, the annual insurance that RMJM took out. It may not matter, but I mean, I'm just saying you'd have to know a whole lot more about the background and the circumstances to form a view on how the aggregation clause is meant to apply in a case of this kind. Yes, no?
Well, it was the year into, it was the annual policy. Because
yes, that's most more likely, I appreciate it.
But I accept that none of, my lord, I'm not submitting that any of these decisions, they're all first instance decisions.
They're all
anyway.
Quite.
So
they're illustrative, and speaking for myself, I'm glad we've been referred to them because it gets one thinking. But I think you're, if I may say so, realistic to say all you get out of it is a very general proposition that you mustn't look too wide in finding a unifying cause. But equally, you can point to Mr. Elkington can point to authorities going the other way, saying that these have a wide effect. These generalisations don't get us very far, do they?
Well, the wide effect, I hope they get us somewhere, my lord. The wide effect is considered by Miss Justice Eder in the Standard Life and ACE case.
Yes.
And that's an example of a wider worded clause.
Yes. Yeah, I saw what you said. I mean, by all means, take to us again. I see how you rely on that in your skeleton argument. But I'm afraid my initial reaction is the same, that in each case the context is rather different on which these general phrases are used.
Most you get out of Andrew Henshaw's decision, it seems to me, is that in that particular context, what's said is it's not good enough to say the architect botched the design, because he may have botched it in a number of different ways, and therefore you say, well, so could a surgeon have botched operations in a number of different ways, and therefore parallel can be drawn.
My lady, yes. That's what I seek to take out of it.
Can I just put you an example that occurred to me earlier, may be helpful to you, although by all means look, it's a gift horse in the mouth if you wish. Suppose you had a surgeon, for the example I give him, probably a gynecologist, who is both an incompetent gynecologist and performs negligent procedures for which the hospital is liable, but also sexually assaults or inappropriately touches his female patients. I think I know the answer to this question. Would you say the aggregation clause would apply there?
Yes.
And you would say that that is because, although both could be said to be a breach of duty to the patient, not in any common sense approach, they are of such a different character. And you say this perhaps though not as extreme, nevertheless falls on that side of the line.
Yes, and in my submission I would say more extreme.
This one is more, do you think?
Well, I mean, I don't want to
No,
but as we fairly said to His Honour Judge Pelling, this course of conduct in the second group of claims is abhorrent, and he was prosecuted for the second group of claims.
Yes, I wasn't, of course, talking about which is more extreme in terms of moral abhorrence.
Oh,
I was talking about more extreme in terms of the different character of what was done wrong.
Well, again, in my submission, the sexual assault is an assault, and the performing an operation where there is no medical justification for it whatsoever is an assault. And then whether one considers that it's where it falls on the scale of assaults involving a deliberate false diagnosis to the patient and for financial gain, it's invidious to argue about which is worse compared to a sexual assault.
Well, of course, but I mean the thing is that one's got that sort of clear in this example. You've got, if you like, what you call a bright line between the assault cases on the one hand and the botched surgery cases on the other. But you could have an in-between situation where the surgeon isn't dishonestly misdiagnosing, but just misdiagnoses because he's an incompetent surgeon and he sees a particular thing which he thinks is a symptom of cancer, which in fact turns out not to be. He performs an unnecessary operation, which is no doubt an assault on the patient because it was an unnecessary operation.
Well, in my submission, that's entirely negligent, but it doesn't have any sense of he wouldn't be prosecuted for an assault because
I don't know whether he'd be prosecuted for assault. He might well be liable for an assault. Exactly. I mean, just to put my lady's example perhaps in a slightly different way, suppose that he negligently, but not for no other reason, negligently fails to get informed consent, perhaps take any consent at all, and that is negligent, then it would certainly be an assault. So, but the assault would be the result simply of negligence. Are you saying that in that case, because it was an assault, it falls into your category where it is different from vanilla negligence?
No, my lord. I'm not suggesting that merely because one applies the label of an assault, to it. That
It's
change.
the deliberate nature of it.
My lady, yes, in my submission. It's the deliberate nature of it and the purpose for which it was done. And if within Mr. Patterson's practice, if he had misdiagnosed, so one of the things which happened was there was an opportunity to stop him that got missed because he got found to have performed an operation on somebody who did not have cancer back in around 98 or 99. And the GP pulled him up on it. And it all got explained away on the basis that there'd been oral reporting of the diagnosis and he had thought that the cancer was there and a mistake was made. Now, if that had been true, that there'd been oral reporting of the cancer, it was a mistake, everybody understood that there was cancer, but in fact there wasn't, that would be negligence and not the type of assault which is going on and was in fact going on in Mr. Patterson's practice, where it was a deliberate assault for financial gain is quite different from, and one has to be slightly careful about post-Montgomery informed consent because it comes up in almost all medical negligence cases. But it's not a situation where an assault happens but inadvertently through a mistake. This is a deliberate assault from a course of conduct beginning from telling somebody what must be one of their worst fears. You've got a tumour or a risk of a tumour where you don't have it.
I just wonder how one draws the line. I mean, take a surgeon who is negligent in that he misdiagnoses. He's also negligent in that he rushes operations, and some of the rush jobs turn out badly for the patient. He's also deliberately this is in the private sector, he deliberately calls patients back for unnecessary follow-up consultations. So he's not committing an assault, but he is behaving dishonestly for his own financial gain. I mean, are those three different original causes? Negligent misdiagnosis, negligence through rushing the job, and dishonesty through requiring unnecessary attendances for his own financial gain.
I would, on the example my Lord has postulated, I would say the first two are one and the third is another.
So you've now shifted ground from when you answered a similar question from me, when you said, when we came back to the orthopod who watches the operation on day one and misdiagnoses on day two, you said there were three different originating causes.
Well, my lady, I wasn't intentionally trying to shift ground.
Well,
and I
you're
hope
entitled to shift ground, it's just...
Yes, it is.
I hope I hadn't shifted ground. In that, I accept, and one of the difficulties, my lady and my lords are postulating, well, where is this bright line that we're drawing?
Yeah.
And to that, I say two things. First, there is a bright line in this case, and it should be drawn. Secondly, I accept that there are lots of examples one can think of where the line is much less bright and may not exist at all. And it's potentially easier simply to say, well, if one individual is involved, that's one original cause, and one never needs to ask what the individual's doing. And I mean, that is a clear line. One then knows what the effect of one originating cause wording is, and insureds and insurers can proceed to continue to use the clause or to change it accordingly. I'm suggesting that if one has a situation where there is a bright line, as in the presence, one should recognise that and find two originating causes. But I accept that doesn't make things necessarily easier in a case where there's a less clear bright line.
The bright line, just to be absolutely clear about it, the bright line is not between something which constitutes an assault and something which doesn't. It's between negligence simpliciter and negligence which also is dishonest.
A dishonest assault, yes, milady.
But then that produces the strange result that if all that Mr. Patterson did was dishonest, criminal, the liability would be 10 million. But if he also does some similar wrongdoing but with no criminal element, then it's 20 million. That's odd.
Well, my Lord's comment reflects that one of the overarching positions in the case law is that aggregation clauses can work for the insured or for the insurer, and it will always depend on the facts who it works for. And that's why in Lloyd's TSB one has Lord Hobhouse saying, well, one shouldn't approach the clause with any predisposition, because after the event it may work in somebody's favour or it may work in the other person's favour. Here the clause is certainly on the present findings of the judge below, working in favour of Spire. The position is that Spire has and would have done the right thing in setting up the compensation fund anyway, and there's currently a second compensation fund because the further review in both the NHS and private sector has identified further patients. So all of that is happening outside the policy context, but in the policy context, Spire is trying to recover, obviously, and the fact that there were these two groups of conduct, if it gives rise, after the Lordship's judgment, to two groups, works in its favour. And I accept that's luck as much as anything else.
And do you say that the bright line is between negligence and criminality, negligence and dishonesty? But suppose there are different types of criminality. You could have a doctor who was both greedy, so deliberately carrying out unnecessary procedures because wanted to make money, and who was also a sexual predator or somebody who got some kind of kick from his power over his patients, but wasn't in fact motivated by money. Are those different originating causes?
Well, they may be if they're distinct and separate. If one's got all the conduct mixed up together on the same patient, it may not be.
No, not the same patient, but a series of patients, as here.
If there are some patients where it's a sexual assault and some patients where it's an assault for financial gain, then on the face of it, in my submission, that would be separate conduct. And neither, this would be an example where there's no suggestion here that Mr. Patterson, for all his other types of conduct, was engaged in sexual assault.
No.
And one of the, sorry.
But both Mr. Justice Jeremy Baker and Lady Justice Hallett said it's difficult to explain the motivation, but it seems to have been a whole lot of things: greed, self-aggrandizement, power, and so on. Except not sex. We can leave that out of it. But how many different types of criminality are different original causes once you start drawing that sort of line?
Well, in my submission, the reason to start considering, and I accept that the facts may mean that there is no line, but the reason to start considering the line is if one just says Mr. Patterson is a rogue, for example, it doesn't actually tell one why he's doing the assaults for financial gain, but why he's not doing sexual assaults. And
why does it matter? I'm struggling, genuinely struggling, with the motivation having anything to do with the cause. I can see that you can say that there are two different types of behaviour going on. One lot of behaviour is dishonest and the other is not. That I understand. But why he's doing it doesn't seem to me to take matters any further. I genuinely struggle with that.
Well, the way the way we put it in the pleading is in the bundle behind tab 9. This is the amended particulars of claim, and over the page on 92, the continuation of paragraph 4. If I could ask my lady just to read to paragraph 5, please.
Which paragraph, sorry?
The unnumbered paragraph at the top of page 92 and
Yes.
the two subparagraphs 1 and 2.
Well, that boils it down very well, doesn't it? You say if the insurance is of a surgeon who is simply negligent, however repeatedly, that's one original cause. If you have a surgeon who is dishonest but not negligent, that's one original cause. If you have a surgeon who's both, that's two.
Yes, and the way.
Yeah, sorry, just to pick up, not disagreeing with how my lord has summarised it, but adding an extra element: dishonest and therefore guilty of assault, because your two builds both in, and probably one leads to the other.
Yes, and we weren't drawing the distinction depending on motivation. I have submitted that the judge wasn't wrong to be considering the motivation, but that wasn't the original basis on which we drew the distinction between the two groups. And then if I could ask your lordships please to turn behind the next tab to the defence on page 115. At paragraph 5.2.1, the appellant admits that it may be possible to categorise the claims in the manner alleged. And that then leads...
Well, hang on.
Sorry.
Yes, of course, but we do need to read the second half.
5.2.3, yeah.
Oh, I just meant that it may be possible to categorise the claims in the manner alleged. No admissions are made as to the relevance thereof. So
Yes.
5.2.2 is gone, of course.
and then as my lady points out, 5.2.3 says more emphatically what is already reserved in the second half of 5.2.1.
Yes. And that then transfers into the list of issues behind tab 13 on page 149. This is the areas of agreement relevant to the...
So which page?
Sorry, my lord. It starts on 148. This is the approved list of issues.
Yes.
And it starts with the areas of agreement, starting on 148. And then over on 149, it's paragraphs 4 is group 1, 5 and 6 are group 2, and 7 reflects the categorisation that we were contending for. Which is the distinction which my Lord, Lord Justice Bean may have been trying to tease out of me, which is that we were...
Negligent as against deliberate.
Yes.
I accept that's more accurate.
And to be fair to the judge, although the way he put it in terms of motivation is not perhaps the most helpful way of putting it, you could say that deliberate and negligent conduct are differently motivated.
Yes.
Without having to pin down exactly what the deliberate nature of the motivation was.
My Lord, yes. And that was until my Lady Justice Andrews' question to me this morning, the way I had understood the judge had meant to be using motivation in his judgment.
Doesn't leap from the page, but yes.
I've rather appreciated that from this morning.
I have a bit of a problem with the distinction between deliberate and negligent as well, because he was deliberately performing STMs.
In at least some of the cases.
In most of the cases, as I understand it, I think there were 3 where it was suggested it was a botch. So that doesn't get you anywhere, does it? Seems to me it's a distinction between negligence and dishonesty, which I can understand, but deliberate negligence and deliberate action and non-deliberate action, I don't think does give you your bright line.
Well, the oddity of his conduct in Group 1, and I don't for a moment condone it, and I'm conscious that the 3 reports and the other contemporaneous documents aren't before you, my lady. But the oddity of it was that he seemed to believe it was in the patient's interests. So he would, for example, consent them on this is what I'm going to do, it's for your benefit.
Yes.
That consent was false because he didn't tell them the risks or that he had been told to stop doing it.
But he was deliberately doing it in most of the cases. It's just that in those cases, his intention was benign as opposed to malign.
I agree on that, my lady, and there's a split of whether he was doing it deliberately or whether he was doing it through rush surgery, which the judge adverts to in his judgment. I think I've already said the problem is nobody's ever been able to get to the bottom of quite what the split is.
Right.
It's, in my submission, not as extreme as my lady's
Right.
suggestion that there were only 3 that were the product of...
Oh, well, I may have picked that up from somewhere and got it wrong. I apologise if I did.
No. It's so roughly 30% of his mastectomies were CSMs or STMs. So he did 70% correctly, and then of those 30%, it's difficult to know quite how many were deliberate and quite how many were the product of botching it.
Yes, I mean, what this draws out is that negligence in the legal sense, breach of a duty, can occur, it's pretty obvious stuff, but it's worth just pinning down, occur through pure inadvertence. You carelessly don't read the notes and don't realise the problem is X rather than Y, or your hand slips, lots of examples of genuine carelessness in the lay sense. Or you may do something completely deliberate, having formed an incompetent judgment that it was the right thing to do. So, as my lady says, deliberateness is not the opposite of negligence. It's a pretty obvious observation, but I'm just teasing it out.
And it's almost inevitable that the action will be brought in negligence. And even if it hadn't been for the fact that the claimants didn't want to trespass on the criminal trial, which would have caused their own trial to be delayed, you would bring it in negligence in order that the insurance did pay out.
It does seem to me that there are two potential distinctions between the groups that might give rise to a broad line. One is negligence versus dishonesty. The other is clinical indication and non-clinical indication. Because in the group 1 cases, they were clinically indicated mastectomies but were botched for whatever reason. And in the group 2 cases, he was doing something which was not clinically indicated.
Absolutely, my lady.
Now that doesn't get you into the problem of worrying about what his motivation is or whether it was deliberate. It does create a bright line between the 2 types of case.
And that, how my lady has just put it is probably less elegantly put in our pleading. But if
it's in there, it's buried in there somewhere.
Paragraph 80.1 and 80.2 on page 108 of the core bundle behind tab 9.
It just seems to me that the negligence versus dishonest involves an awful lot of, sort of speculation about somebody's mindset, which you wouldn't necessarily be looking at when you're looking at causation. But I can see that you could say, well, there is a world of difference between a liability arising out of somebody doing what they are paid to do, namely operating on patients who have a clinical indication for a particular condition and making a mess of it for whatever reason, or misdiagnosing, or doing all sorts of things like that, and deliberately, well, forget about deliberately, carrying out operations that are not clinically indicated.
And I would respectfully adopt my lady's point, which I hope is reflected in the difference between the 2 claims at 80.1 and 80.2. my lady is, or whoever made the point is correct that it's buried in there. There were a lot of points in issue in the underlying, most of which were conceded during the trial. And that's, therefore, the pleadings cover quite a lot more ground that isn't before you.
Yes. Do I get the impression, Mr. Shapiro, that you're wondering whether you've covered the ground? I'm beginning to think you have. It's been a very helpful discussion. But obviously you weren't expecting to go first, so you want to be sure that you've covered the points you wish to make. There is one, assuming you've otherwise think you've covered the ground, there is one point I think we ought to hear you on, which is whether there is any important conceptual difference between source and cause.
Yes.
Or any difference at all. But are we otherwise, you haven't referred us to all the authorities, but I think you have referred us to the ones that you think are most helpful to you, and most of the rest are not contentious. The truth is they set out certain principles. The question is how they apply in this kind of case.
Yes. In terms of the authorities, the two that I haven't taken your lordships to are the INSCO authority and Scott and Copenhagen Re.
Yeah, it's up to you whether you feel you need to, but
I would only be taking you to them for the proposition that there's got to be a limit to the, obviously originating cause is not a proximate cause. I don't think that's an issue. But there's got to be a limit to the extent of the remoteness which is acceptable in finding the unifying factor. That's Mr. Justice Moore-Bick, as he then was on page 414. It's the authorities bundle tab 3 at 20, but I perhaps don't need to turn it up. It's also reflected in Lord Justice Rick's judgment in Scott and Copenhagen Re at paragraph 68. But again, I may not need to turn it up.
Can you give me the reference to Lord Justice Moore-Bick again, please?
Yes. May I
Tab 3.
quickly?
20.
It's tab 3 of the first authorities bundle. It's on page 20. Sorry, it's not tab 3.
I was going to say that's Cox and Banks.
I'm grateful. I apologise. I've given you. It should be tab 5 on page 74.
Thank you.
Sorry, so I'd given my lady completely wrong reference.
Thank you.
And it's in column 1.
Yeah.
It's the start of the paragraph I fully accept that we rely upon. And then we also seek to rely on, although I'm conscious that it's not entirely on all fours with this court's analysis, the view that Mr. Justice Moore-Bick took of Cox and Bankside starting halfway down that path. And then the two references in Scott and Copenhagen that my lady was asking for are to paragraph 63 on page 137 behind tab 10 and 68,
Yes.
the passage on 138.
Yes, thank you.
In particular, a plurality of losses is to be regarded as a single aggregated loss if they can be sufficiently linked to a single unifying event by being causally connected with it. Just before I answer my Lord's point on
Yes.
source, the one reference I was going to take my Lord's to, which I hadn't yet done, was in the defence behind tab 10 in the core bundle. On page 126, paragraph 23, your lordships will see the other side of the genesis of the agreed common ground. And again, picking up on my lady's point about having no clinical indication, that's admitted at paragraph 23.2.
Yes, actually, this isn't actually pleading to the paragraph in which that was pleaded. It doesn't matter. Because that was in paragraph 80, wasn't it?
It's then repeated again at paragraph, in relation to paragraph 80, over on 132, paragraph 45. It says, as to paragraphs 80 to 82.
Yes, and you're right, it goes back, it refers back to 23. Yeah. Thank you.
My Lord asked about a source.
Yes.
And in my submission, there's no material difference that the addition of that word makes. So what it's doing, as Mr. Justice Eder said in the ACE case, is further emphasising that the doctrine of proximate cause is not to apply where one's talking about originating cause. It doesn't make any practical difference to the approach of the cause. It has not, in fact, made any practical difference to the approach of the cause. And the particular passage that my learned friends rely upon in the AIG Europe Court of Appeal decision, which is in the second authorities bundle at tab 17. They rely upon Lord Justice Longmore's statement. It's on page 347. 347.
347.
my lord. I apologise. And you'll see that he refers to the traditional well-known way in which to formulate an extremely wide aggregation clause. And he gives two examples. One does not have source, the other one does. And there's no suggestion that it's made any difference to the width.
It did occur to me that Justice Eden may be right, certainly about the effect of the words or source, but I suspect this phrase has been going around an awfully long time, and back to a time when draftsmen tended to use more words than they need. And it may well be that there actually isn't any carefully thought out rationale. It's just two shots at the same target to make sure that fancy points aren't taken on source or fancy points aren't taken on cause. We'll put them both in.
Well, my lord, I'm confident that Mr. Justice Eder will have given more thought to the clause than the original draft. And he's come up with a sensible reason for it. But the short point is there's no practical difference between. And if one looks at the two lists of menus in Malone and Friends' skeleton, one can see that there's no principled difference between the two lists. So oddly, in one list, one has Mr. Patterson as the source, but in the other one has Mr. Patterson and his conduct.
Yes.
No
I noticed
between.
that.
And one misses out, I think it might be negligence in source. But there's no principled reason for that. It has the same effect. And if I'm wrong about the effect of originating cause, source won't help me.
Thank you. Right. Have you said all you will obviously have a chance for reply? That's one advantage of being put in this position. Is there anything else you want to say at this stage?
My lord, I'm conscious that it's not going to assist the court. I'd be more sensible to wait to say anything in reply. Anything further that I said would be in relation to the facts, which my lords, I don't believe are really in dispute.
No, I think you very sensibly went straight into the real issue in the case. You must say anything you want to say. I don't want to rush you, but if you're asking for a steer on whether we're interested in hearing more about the facts, I certainly, so far as I'm concerned, no. Doesn't look as though my lord and my lady are in any different position. Right. Thank you very much, Mr. Shapiro. Yes, Mr. Elchington. I think you can follow Mr. Shapiro's lead in going straight to the heart of it. The issues have become, well, I suspect they always were ultimately quite focused, but they've certainly become quite focused as a result of the debate.
Yes, that's very helpful. One thing I want to say at the outset, not least my client would be very anxious if I did so, is that the outcome of this appeal will have no effect on the victims of Mr. Patterson. They've been compensated and they will remain compensated irrespective of the outcome of this appeal. And what I would like to do is take the court to the policy, since we haven't looked at it yet, and to make some observations about it, because they provide the framework in which the aggregation issue must be determined. And the policy is in the core bundle behind tab 14. So I think what would be most useful is if I look at the policy, I could probably then skip the authorities that I was going to take the court to, and then look at how I say the policy should apply on the facts of this case. And we have it behind tab 14 in the core bundle. I just want to turn through it and identify some important points, if I may, please. The first is the definition of the insured on page 159. That's Spire Healthcare Ltd, a number of other companies and their subsidiary companies. And Spire's, it's a very large group. You may have seen reference in the opening to it having a turnover in 2018 of over £900 million. And it operates dozens of private hospitals over the country. And that's reflected in the definition of business there. Owners and operators of a professional healthcare service, primarily providing medical and surgical treatment in independent hospitals and like institutions, including property owners. Then the policy schedule is over the page, and it's a combined liability policy. So there are separate sections for employers' liability, public product liability, medical negligence, products liability, medical products, etc., each with their own limits of liability, and each with different aggregation clauses. You'll see in the right-hand column, the first 4 are any one event, any one event, any one event, all events, and then a different one against section 4, which is the medical negligence cover. And that's the one which we're concerned with in this claim. And in relation to that section 4, it's £10 million, and as the Court of Appeal determined when this first came before it, that's for all linked claims, if I can use that shorthand. And then there's an overall limit of £20 million, however many claims there are, whatever linkage there might be between them. 20 million is the most that the insured is ever going to get.
Where do we see that? I know that's the case.
Indemnity.
It's the right against medical negligence by the lower hole punch on page 160, and on the right hand side.
Oh, of course. I'm so sorry. Yes, of course.
Anyone
yes. Yeah. Yeah.
Then if we could turn on to the definitions, please, at page 165. And as we'll see in the insuring clause in section 4, it provides cover for medical negligence. So we need to look at the definition of medical negligence. And it's at 165 by the lower hole punch. Medical negligence will mean actual or alleged negligent error or negligent omission committed by any person entitled to indemnity, which arises from the conduct of the insured's business as defined in the schedule or the performance of a good Samaritan. So medical negligence is limited to the acts and omissions of a person entitled to indemnity. So who then is a person entitled to an indemnity? And that's defined at over the page 166. And I needn't run through all the wording because it's common ground and has always been that Mr. Patterson himself is not a person entitled to an indemnity. Having looked at those clauses, we can go on to the relevant section of cover, which is at page 193. And the first point to note at 193, this is the start of the medical negligence section of cover, is the general memorandum. In respect of section 4, medical negligence, the indemnity provided to any principal, any director or partner, any person employed, that's picking up the definitions of person entitled to indemnity, will not apply to any...
So sorry, where are we reading from?
I'm so sorry, at the top of page 193.
Oh yeah. Oh sorry, yes.
Under the heading General Memorandum. Yes. Will not apply to any doctor, surgeon, consultant, midwife, dentist or resident medical officer. So even if, for the other purposes, the other sections of the policy, Mr. Patterson was a person entitled to indemnity, there's an express carve-out for the medical negligence section, meaning that there's no cover for his conduct, direct conduct, as it were. And the reason for that is that the surgeons, like Mr. Patterson, have their own insurance. He was a member of the MDU, which insured him and contributed to the settlement. And then when we look at medical negligence cover, a few further inches down, under the first paragraph, under the heading medical negligence, says the company will provide indemnity to any person entitled to indemnity. As I say, that's not Mr. Patterson. against legal liability for damages in respect of accidental injury of any person arising out of medical negligence. So, to obtain cover under the policy, Spire needed to show that it had a legal liability for damages in respect of accidental injury of any person arising out of medical negligence. I think it would be helpful just to identify
injury is a defined term, and accidental isn't, right?
Accidental is not a defined term. In relation to accidental, one might say, well, a lot of Mr. Patterson's conduct was quite the opposite of accidental. But what's common ground is that accidental needs to be considered from the point of view of the insured, Spire. So far as Spire was concerned, these injuries to the patients were all accidental. Spire did not direct Mr. Patterson to act in an improper way. So they're accidental from Spire's perspective. And all the issues we're addressing today need to be considered from the perspective of the insured, not the perspective of Mr. Patterson. And it may assist the court if I could to look at the relationship between Spire and Mr. Patterson, which is most conveniently set out in the supplemental bundle.
Sorry to be, and just before you do that, I said injury is a defined term simply said a capital I, but that doesn't always follow. Is it in fact a defined term?
Yes, it is. It's on page 165. Slightly different definition for section 1 than there is for section 2.
The only reason I'm interested in is, so if it was section 4...
We're section 4, so it's the second definition. It's very wide.
Yes, I would just had the back of my sexual assault example. Yeah. Okay.
There's no suggestion that would fall outside the definition.
Sorry.
There's no suggestion that the assault would fall outside the definition.
No, but quite. But sexual assault might not cause injury in one sense, but it certainly would in this sense, because as long as it caused mental anguish.
Yes, mental shock.
Sue unless it did. Yeah. Okay. Thank you. Very helpful. Sorry, where were you about to take us to?
I want to come back to the policy because we've got to look at the aggregation clause. But again, before we do that, I'd like you to take you to the supplemental bundle, please, and invite you to turn to tab 3. And what you're looking at there is Spire's Part 20 claim in the managed litigation. So the test case was started, 7 patients suing each of Patterson, Spire and the NHS Foundation Trust. And within those proceedings, Spire commenced additional claims against Mr. Patterson and the NHS Trust. And these are where it spells out that claim. And it sets out at page 86 the relationship between the different individuals. And if I could just invite you to read paragraphs 10, 11, 12, 14 and 16, please.
Why was Mr. Patterson a protected party?
Sorry?
Why was Mr. Patterson?
He claimed that he didn't have capacity to conduct his own affairs. Yes. So you've seen there that Spire entered into contract with patients, and Mr. Patterson entered into contract with patients. And so far as Spire is concerned, Mr. Patterson was an independent contractor, and it was accepted before the judge that to show that the hospital was vicariously liable for Mr. Patterson's conduct would have required an extension of the law of vicarious liability. And then while we're in this document, could I take you to what Spire, the allegations that Spire put forward against Mr. Patterson at paragraph 30. It's on page 89 of the bundle. And just invite you to read paragraph 30, if I might, please.
Out of curiosity, and I think it probably is just curiosity, were the first claims typically brought against Spire or brought against, and they were eventually managed into this, but before you got any group action, who were the primary defendants? Was it Patterson or Spire?
Well, he mistreated patients on an industrial scale. We know that. So far as the NHS is concerned, we know that from the Bishop's report that by 2020, £17 million have been paid out by NHS resolution. We don't know the precise number of figures.
Yes, I wasn't so much, I was thinking more in the private hospital claims, because I think my experience doing medical negligence claims a long time ago, typically in a private hospital claim, my old-fashioned instinct would have been simply to proceed against the doctor.
Well, I'm instructed that what typically happens is that letters of claim were sent to all three
Yes, I
targets.
see. But why exactly? Why
limit it?
Why limit it? Yes. Okay. Sorry, it's probably a red. I'm sure it's a red herring.
And so, focusing, just picking up 2 points in the allegations of breach. Subparagraph 30A2 is dealing with what Mr. Patterson branded cleavage-sparing mastectomies, and common ground that those were experimental and unrecognised forms of mastectomies. And when one's thinking, are they clinically indicated? They're never clinically indicated. If someone needs a mastectomy, the whole breast needs to be removed. Because if you do a CSM, which is a form of subtotal mastectomy, the danger is that you leave cancerous breast tissue in situ, which then may spread to other parts of the body. So the suggested distinction between clinically indicated or clinically not indicated is, in my submission, is a distinction without difference in this circumstance, because some surgery was clinically indicated, but not the surgery he performed. And then
Yes.
The other point to draw out is the point at paragraph 30D, which is that there was a time when the balloon had gone up to a limited but not full extent in late 2007 and early 2008, when Mr. Patterson was told to stop doing CSMs because they were unrecognised procedures and inappropriate. And he agreed he would stop doing them, but he carried on doing them. And Spire doesn't draw any distinction between the pre and post agreement to stop doing them when it's looking at the nature of his conduct and that group. There's just a common, all those claims are put into what it calls Group 1, even if some of them after he has agreed not to do the surgery anymore. So again, it makes it difficult to say that that group's just merely negligence when part of it includes carrying out of operations which he had agreed not to carry out. And he'd agreed to carry them out because they were, as pleaded here, an experimental and unrecognised form of mastectomy. Before we leave this Part 20 claim, I just draw attention to paragraphs 31 and 32, which is spelling out the case for causation and loss. Saying it was foreseeable that if Mr. Patterson repeatedly provided treatment without informed consent, then Spire might face claims for damages. And 32, in the circumstances, Spire suffered loss and damage, claims damages for its liability to the claimants. So every single case is operating without informed consent. And that's what's caused the claims against Spire. Now, I identified in the policy the different ingredients that need to be satisfied to show that Spire is entitled to cover, and I just want to run through those, if I might. The first is that it's a person entitled to indemnity. That, of course, is Spire, but not Mr. Patterson. The second is that there is legal liability for damages. And there's no dispute between us that Spire had to spell out and show its liability for damages in order to be able to recover under an indemnity policy. And it's helpful to see how it said it was liable, and it spelt that out in its particulars of claim, which are behind tab 9 of the core bundle. Because of course there was no determination of its liability because the whole matter was sensibly settled. The paragraph 67 of the particulars of claim, behind tab 9 at page 104 of the bundle, Spire set out how it was liable to the patient. It said there were I'll just leave you to read the 4 different bases in paragraph 67, if I might.
It occurred to me when I first looked at these that 67.3 and 67.4 were probably more promising than the others, but
Yes, well, the significance of 67.1 is the distinction between Miss Lloyd Owen, who was an employee,
yes,
and Mr. Passon, who wasn't.
Yeah.
The hospitals had hundreds of staff, and it had hundreds of consultants who
Yes.
had practicing privileges. The staff were employees, and the hospital was vicariously liable for them.
Yeah.
The consultants were in a different category. And what you will note in relation to those four bases of Spire's liability to the patients is that there's no difference there between the natures of Mr. Patterson's conduct, be it intentional, unintentional, dishonest, negligent, or whatever. That's neither here nor there, so far as the hospital is concerned, the hospital's liability. And similarly, so far as Spire's entitlement to an indemnity from RSA is concerned, it makes no difference whether or not what the nature of the conduct is.
Well, it's got to be clinical negligence, medical negligence.
Well, by the hospital, yes, but not by
Yes.
not by Mr. Patterson.
Yeah.
The nature of Mr. Patterson's conduct is neither here nor
I take
there.
the point.
If the hospital is otherwise liable for one of the four reasons put forward here.
Yes.
And I think at this point it would be helpful to take you to how this was put in the in Spire's opening in the trial, which is in the supplemental bundle at tab 10. Behind tab 10 is a long opening, written opening of the trial. If I could ask you to look, please, at page 193. At the top of the page, paragraph 5.61. Invite you to read that.
So sorry, which page?
Page 193 in the supplemental bundle behind tab 10. That's the paragraph at the top of the page. And
Just sorry, I haven't had a chance to read it yet.
so sorry.
Yes.
And it's the sentence 4 line down, which is absolutely right. Neither the Group 1 or no Group 2 claims arose out of or consequent an original cause of management failings. They were consequent or upon Mr. Patterson's various actions. The management failings allowed Mr. Patterson to continue practicing at the hospitals, but were not the source or course of each strand of his conduct. The source or course of the claims was Mr. Patterson's conduct, and irrespective of how one pigeonholes his particular conduct, the liability of the hospital is the same. And that's why it's because we're looking at the insured's rights against the insurer, Spire's rights against RSA. That's why it's commercially absurd in my submission to try and reach a construction of the various clauses, which means that the entitlement as between those parties depends on the motivations of someone who's not going to be giving evidence, or indeed the proper characterisation of the quality of his conduct, be it honest, dishonest, assault, negligence, or whatever. That person's not going to be at trial giving evidence in the dispute between the insured and the insurer, and where the insured's liability arises out of its own failings. So I said that there are 4 ingredients to the liability under the clause. We've got personal entitlement to indemnity, we've got legal liability for damages, and you've seen how Spire put its case that it was legally liable for damages. Thirdly, in respect of accidental injury, I've touched on that already. Accidental means accidental from the insurer's point of view, Spire's point of view, and all these injuries, these poor patients' injuries, were accidental from Spire's point of view, irrespective of the intention or otherwise of Mr. Patterson. So no distinction there between the Group 1 and Group 2 claims. Just the liability and the entitlement to cover is the same so far as Spire is concerned. And then lastly is arising out of medical negligence. And I've touched on that already. We've seen the definition, not Mr. Patterson's acts or omissions that are the insured conduct, because he falls outside the definition of medical negligence because he's not a person entitled to indemnity. It's the hospital's acts and omissions which gave rise to its liability. And no distinction drawn there between Mr. Patterson's conduct and the different groups. So that's the context in which one has to then look at the aggregation clause within the policy, understanding who's the insured, what's the insured covered for, what acts and omissions and so on. Because until one's looked at those issues, one can't sensibly construe what this clause should mean between a provider of hospitals and its insurer. And the aggregation clause, as we call it, is at page 194 of the core bundle, behind tab 14.
Oh, sorry.
My fault.
And it's clause 5, and no doubt it's been carefully read and highlighted already. The total amount payable by the company in respect of damages, costs and expenses arising out of all claims, and just pouring there, that's necessary claims against Spire for which Spire is entitled to an indemnity, because otherwise this clause has got no relevance to anything. So it's claims against Spire for which Spire is entitled to indemnity during any period of insurance consequent on or attributable to one source or original cause, and one can skip the next line and a half, shall not exceed the limit of indemnity stated in the schedule. And that's, as the Court of Appeal determined, the £10 million figure rather than £20 million. And so if there's all those claims do aggregate, so there's £10 million limit indemnity for those, then the balance of the £20 million, another £10 million, will be available to pay other claims. And this is the clause that was negotiated between these two substantial concerns. We're not looking at an individual or an SME's policy, we're looking at two substantial organisations. And a theme we see in the cases, I don't think I need to take you to them, is that the court should respect the party's choice of aggregation clause, because that tends to be a key issue of negotiation. And you've seen how in this policy, different sections of the policy have different aggregation clauses. And what the parties have selected here is a clause which has been variously described as extremely wide, and one which requires the widest possible search for a unifying factor. So we have consequent or attributable to one source or original cause. Now, in my submission, those are different words with different effects and different meanings. The ordinary definition of a source is a place, person or thing from which something originates. So a person, like Mr. Patterson, would be a source. It's a source of claims. A cause is a slightly different type of word and describes why something has happened.
Well, I see why you say that, but you don't really need to go there, do you?
No, I would. No, it's one of those belt and braces of points.
Yeah,
but
it's not a particularly good one, if I may say so, Mr. Whitson. It's not your best point.
Well, what I would submit the
what
proper.
You're really looking for is the origin of the claim.
Yes. Yes.
Whether you describe it as a source or the original cause, what you're looking at is something which is the foundation for the claim, the primary foundation for the claim.
Is there a unifying factor?
Yeah.
And if you were sitting in Spire's claims department, getting hundreds and hundreds of letters of claim from hundreds of patients, you wouldn't have to be a brilliant claims handler to say, hello, I spot a common theme here.
Mr. Patterson.
It's another Mr. Patterson one. Put that on the Patterson pile.
Yeah.
I mean, just to risk irritating my lady, one way that one might see these working differently is to say the claims are all against Spire. They're all consequent upon Mr. Patterson's surgery. It's him doing operations, mistreating, abusing patients time and again. That's, as it were, the immediate cause of the claims. The source of each of those claims is Mr. Patterson, who is doing the surgery. If one wanted to...
Well, you could choose to make a distinction, but when could the two ever produce a different result?
Well, one toys with all sorts of various examples. One example I toyed with is, for example, if Spire had got surgeons through some sort of locum clinic which put forward two surgeons which it knew were not fit for the job, and they operated on patients. You might say, well, the cause of those claims are the two surgeons operating inappropriately, but the one source of them is that they come from a inappropriate locum providing agency. But equally, you might say, well, the cause is the fact that the locum agency had a willingness to put forward inappropriate surgeons for roles.
Or didn't carry out its vetting procedures.
Yes, whatever it might be.
Yeah.
But they're definitely, in my submission, different types of word, source and cause. They're both
Well, they
noun.
can be, depending on the context.
Yes. But
They could actually be treated as synonyms in this context.
Yes. Well, I absolutely don't suggest that our appeal is in any way dependent on persuading you there's a difference between them. As I was saying, so the source of each claim is Mr. Patterson, who did the surgery. The cause of the claims was his carrying out of surgery on each patient without their informed consent. Every single one, he operated them without their informed consent. No one would consent to surgery when they had no cancer. No one would consent to surgery which left them with the risk of further cancer, because there wasn't a complete total mastectomy as there should be. One doesn't want to say which is worse of those two, they're both abhorrent. And the cause of Mr. Patterson carrying out surgery without informed consent was that he was a rogue surgeon who over at least 14 years disregarded his patients' well-being and was willing to knowingly operate on his patients without their informed consent. He was the rotten apple in Spire's basket of surgeons to whom it had granted practicing privileges.
Well, you've got thrown out all sorts of formulas there. I must say that although useful shorthands, phrases like rogue surgeon and bad apple don't confront the argument against you. Your real point is they are all cases of surgery without informed consent, and all cases where, I think you used the phrase mistreated, but I've got that maybe.
Yes.
But something like that.
Yes. What would then probably be most helpful to the court if I then address square on the categorisation of the claims by the claimant, by Spire, by reference to paragraph 80 of the particulars of claim. Which is in the core bundle behind tab 9.
Before you do, I can see why you say the unifying factor is a lack of informed consent, because that is one unifying factor that you could find. But another is that in all of these cases there was negligence, whether you call it gross or any other form of negligence, by one individual surgeon who is carrying out botched operations or unnecessary operations on patients.
Yes.
Now, let me put to you the example that I put to Mr. Shapiro, where you've got Surgeon X, who on day 1 fails to spot the compound fracture, day 2 botches an operation, orthopaedic operation, day 3 tells the staff in relation to recovery that they should give somebody physiotherapy when it's not clinically indicated, and it makes their recovery far worse. Now, in that example, you've not got a lack of informed consent running through the two. Would you say you've got 3 separate causes or 1?
No, from the point of view of the insured, which is the hospital, we'll have to take a step back and think, well,
Yeah.
how would there ever be a liability on the hospital, and how would the hospital be entitled to an indemnity?
Yes.
Because one doesn't even get to aggregation until you've got that.
Yeah.
Now, on its own, if those were three distinct events with nothing more, the hospital would not be entitled to indemnity, because these are acts and omissions of the surgeon, who's not a person entitled to an indemnity.
Yes.
So the example is one needs to build in some, as it were, management failure.
Yes. Let's
Say they
let's
knew
assume
he was
you've
a
got
road
management failure, or you've got an employee like the lady in
Yes,
this case
yes.
who was aiding and abetting, who's actually
Yes,
involved.
indeed. And when one builds that in my submission, it's clearer that those all arise from one cause or one source, which is that the Spire has granted practicing privileges to this particular doctor, and and he is the cause or the source of the cause. Because then,
But then I think then you're agreeing with my lady, because the logic on the logic of that argument, it's irrelevant that he hadn't, that the form that his mistreatment of the patient's cause took
yes,
was a lack of informed consent. Sometimes it would, sometimes it wouldn't.
yes,
As Mr. Shapiro said, I think probably informed consent is now plays a larger part in medical negligence cases, but it certainly isn't characteristic of all of them.
no.
So are you accepting that actually it's not, the logic of your position is not to emphasise the lack of informed consent in all these cases? Well, it happens to be present, and if you think it was good enough for you, so be it. But for us trying to look at the wider analysis, it's not the best way of looking at it, is it?
Well, it may be that the best way to look at it is to focus on Mr. Patterson, that he was a person who habitually, his character was such that he habitually and happily carried out surgery week after week without his patient's informed consent.
Well, why even put it? Why put it in terms of his character, and why put it in terms of informed consent? Why not say that the unifying factor is that these are all cases in which Mr. Patterson acted in breach of his duty to the patient?
Yes.
I mean, I don't want you to accept this, just I'm putting it to you. I'm trying to think it through and see
Yeah.
where it goes.
Well, I hope that I had tried to accept that by emphasising, as it were, the need to identify that just these examples taken on their own won't arise.
Yes. Well, we take the point about the distinction between the assured and the person for whom they are not directly liable, who is not an assured under the policy. Get that point entirely. But as my lord says, it may well be that in this particular case, a single thread is the fact that the form which the surgeon's breaches of duty took was a bright line of failure to obtain informed consent right across the board. But it shouldn't matter, should it?
No,
as long as the hospital has a legal liability that arises in consequence of their having allowed somebody who is behaving negligently towards patients to operate in their private hospital.
Yes.
Perhaps we
I
confuse the analysis by talking. I confuse the analysis by talking of in breach of duty or negligently. Perhaps it's harmfully.
Well,
Because the risk of putting terms of negligence and so on suggests that the doctor himself is the person insured.
Yes.
The actual any question need for any legal breach is at the earlier stage of whether there was some medical,
Yes.
whether there's a liability.
I certainly wouldn't want to suggest that I need to identify as a common theme operations which had a common theme, namely informed consent. It is sufficient in my submission that it's all carried out by the same individual. That Spire has operating and given practicing privileges too. He is the cause, the source, the one source comes first, or original cause of all these claims. Because original cause says you have to open up the widest possible search for a unifying factor. And in fact, you only need to step about 2 yards down the road to find the unifying factor.
Now, I see the time. Would that be a convenient place to break?
Yes, indeed. And then I'll tackle the paragraph 80 points after
Yes.
lunch, if that helps.
Very well. 2 o'clock, thank you.